judicial precedent or state decisions we call it now signifies as an independent source of law, is not as old as custom and as modern as legislation. The term state decisions signifies that when a point of law has been once settled by a judicial decision, it forms a precedent which is not to be departed from afterwards. Though the function of judges is not to make the law but to interpret, and in the process of interpretation of the law, the judges silently and indirectly effect the development of law by laying down some broad general principles upon which they base judgments. It is these broad principles which becomes binding in the subsequent cases on the lower courts. Now let us understand this term precedent, that how it is applicable and what is its usage in the daily routine work of litigation. Accordingly, in almost any form of organization, we see precedent has to be established as it guides to future conduct, and this applies not only to legal system but to all rule or norm creating institutions, whether they may be clubs, government departments, schools, business firms or churches. Although there is an inevitable danger that the tendency to follow past decisions may lead to stereotyped procedures and so stultify progress, yet precedents have been regarded as lifeblood of legal system, whether primitive, archaic or modern.